So who gave us this constitution? You said Ambedkar and Constituent Assembly is the answer, right? But let us read the constitution preamble format. We, the people of India, having solemnly resolved to constitute India into a sovereign, socialist, secular, democratic republic, and to secure to all its citizens justice, social, economical, and political, liberty of thought, expression, belief, faith, and worship, and equality of status and opportunity, and to promote among them all fraternity, assuring the dignity of individuals and the unity and integrity of the nation in our constituent assembly on such and such a date. Okay. And give to ourselves this constitution. So who gave us the constitution? We gave to ourselves. Nobody else gave. Then who should protect it? We should protect it. But that was sought tried to be clamped in the name of emergency. Okay. So therefore, okay, where are these emergency powers enshrined? Any idea? Article 352 to 360 in part 18. Right. Now, before we look into the topic called 15 years of national emergency, so we have to talk, our center of talk would be what is the impact of emergency. But we should go a step behind and say what was the status of emergency, status of law prevailing and the constitutional provisions and the judicial pronouncements touching upon the constitution in the pre-emergency stage. Okay. So people think that after the emergency, Supreme Court got activated and the term called judicial activism in India emerged after the withdrawal of national emergency. But that is, in fact, in a way, incorrect. The reason is like this. When did the emergency happen? Between 1975 and 1977. Much before that, in 8 years prior to that, there was a case called Golaknath case in 1967. This is where the Supreme Court held. You are all aware. I am not saying something new to you. I am only refreshing your memory. Okay? Right. In 1967, Golaknath case, the court held that Parliament cannot curtail the fundamental rights of the people as enumerated under Part 3 of the Constitution. So what did it do? It has demarcated the limits of legislative majority. This is how it happened in Golaknath case. So then, this is the first direct judicial effort to distinguish between two things. One is called constitutional democracy from conventional democracy. In conventional democracy, what happens? Where legislative majority alone matters. Because in a democratic society, the legislative majority will prevail. But constitutional democracy is something above that. This is exactly what is said in Golaknath case. So, constitutional assertion over what? The political whims and fancies which are indirectly negating the constitutional democracy. Now, what happened in this Golaknath case is, let us not go into the details of the case. When a case is there, somebody has to argue. And one gentleman, one advocate, senior advocate, by name M.K. Nambiar, he argued in favor of basic structure. And how did he argue on that? It is, he was influenced by a lecture of Professor Dietrich Conrad. He was talking in Banaras Hindu University in 1965. Okay. On the topic, implied limitations of amending power. Who has the power to amend? Legislative. So, what is not said in the text? What has to be seen in the text? This is by implication, right? So, the implied limitations on the legislative insofar as this amending power of the constitution. This is what exactly he was a topic he threw to the audience in that way. At Banaras University in 1965. And that argument was accepted and reflected in the judgment. And who is this Professor Dieter Carnot? He believes that written constitutions have in them implied limitations also, and that the judges should use these limitations to protect the constitution. So the constitutional text on its own would not able to carry anything. So this is the thought he has put as a question to the general public, which is taken by M.K. Nambiar, Sir M.K. Nambiar, and presented to the court, and the court accepted that, and it is brought into the judicial pronouncement in Golaknath case. Keep this name in mind for a moment. We'll talk about this name a little later. This is in 1967. Then comes Keshwarananda Bharti case. This is one more landmark judgment. Then, here in this, the concept of basic structure, the concept of basic structure of the constitution is discussed. It says the basic structure of the constitution cannot be touched by invoking legislative process. So many ideas like secularism, so many things have went into the process. But what ultimately is it? It decided the basic structure. This is what we need to get into it. And where it resembled the eternity clause in the German constitution on the inalterability, that it cannot be altered, of the constitutional tenets. Constitutional tenet is again basic structure. You put it in a different format, it is called basic structure. So, and then what it said again is that it stalled. It has actually, this case, Keshwarananda Bhartika stalled the legislative onslaught. And why this legislative onslaught happens? When certain political interest or personal interest try to play its role in the game. So my political interest, the party at the helm of the affairs, my political interest or my personal interest should not tamper with the constitutional tenets. This is what it is said. But here is a beautiful thing which we have to carefully understand is, how did this Keshwarananda Bharati principle on basic structure has come into play? It came up with a minimum thin majority. So the majority in this case was very thin. The judges' majority was very thin. So even somebody going this side, it would have been toppled down. But it stood to the time. And what is it saying? Personal and political interest, onslaught should be stopped. And at the power, at the helm of the affairs, the then Prime Minister was Indira Gandhi. She did not like this. She was irked by the powerful statement. So then this judgment has to go. So that is how the challenge of this judgment posed against what the executive and the parliamentary majorities. Because of this judgment, around 3 judges were, they have decided to resign, and their junior on the bench, Justice A.N. Ray, was elevated. Okay, so then what happened? This is in which year? 1973. This has sown seeds in the mind of the then Prime Minister, that the political and judicial tussle between these two has cropped up and finally came out as an emergency. So these many things have been taken place to protect the constitution. And that constitution is guaranteeing part 3 of the constitution is fundamental rights. So many things have to be protected for the general public. Who should protect? Who gave you the constitution? We gave to ourselves. So who should protect us? We have to protect ourselves in the name of judiciary and judicial pronouncement. So that is how there is a very important situation that has cropped up at that point of time. So then during the emergency, so many things have happened. So many things have happened. This is where now we are coming into the stage of entering into the state when the emergency was in operation. In spite of so much of battering the constitution, the judicial courage and legislative correction has not lost its sight. It was very well there. So the judicial intervention in Keshavananda Bharati, it already held that parliament cannot alter the basic structure. And Indira Gandhi Rajnarayan case in 1975, it struck down amendment of 39 amendment was struck down, holding that free and fair elections are part of basic structure. Because election, unless it is there, it is for the public, elected by the public, for the sake of public. So therefore, that cannot be altered. And now, during the emergency, said, emergency is clamped. So let us not say that all of a sudden the then Prime Minister Indira Gandhi thought of emergency and he clamped it. She has been put under a lot of pressure. All her powers of legislative powers were in question. And there is something staring at her about the basic structure. So at this juncture, is preceded by series of political, legal, constitutional developments. Okay. That has paved way into the extraordinary suspension of democratic norms. It is not individual norms, it is democratic norms are at stake. What happened? Politically, the Congress party was facing massive agitation at given point of time. Why did the emergency come into play? So Indira Gandhi was under a lot of pressure from the opposition, I think Jay Prakash Narayan and somebody. Yes, okay. Then there was almost a total revolution. Then, at that point of time, that is on June 1275, Allahabad High Court has given a verdict that Indira Gandhi, look, madam, your election is not valid because of election malpractices. Court found that she is guilty of election malpractices, invalidating her 1971 election and disqualifying her from holding the office. Then what happened? Obviously, from Allahabad High Court, the only one-way traffic route is to go to Supreme Court. Supreme Court interfered. But how? Conditional stay was granted. What is that conditional stay? That she can remain as Prime Minister, but she cannot vote in the Parliament. What is the purpose of? So, that is how our ego was at stake. Then constitutionally, what did it? So, one is political situation. The other is judiciary situation. The third is constitutional. What happened is 38th amendment was brought, whereby the power of judicial review in case of emergency declaration it is immune from judicial review. So the whole power vested to review a situation if a declaration of emergency takes place is withdrawn. This is the dangerous situation over there. So that 38th amendment is talking about emergency. If it is declared, that is final and conclusive. Nobody can interfere with it. So that barred the judicial review, and that is how on 25th June 1975, emergency was clamped on the grounds of internal disturbance. And which article is talking about emergency? Article 352. That doesn't have this term called internal disturbance. Okay, but this is a vague phrase. However, she did it. And now where is she taking protection? Under 38th amendment. So that 38th amendment which is there, emergency cannot be questioned in judicial review. Whether it is vague phrase or a wonderful phrase, it cannot be touched by the Supreme Court. This is the status. Then, once the emergency is clamped, it not only did so many things, but also brought in serious, severe constitutional amendments. Importantly, we can talk about 38, 39, and 42. So these amendments are generally termed as legal engineering. Engineering is creating something which is useful, right? So this is legal engineering. The other day, the CJ of our High Court was saying, this is a draft, English engineering, legal engineering, where your drafting is so clever that you are trying to protect a figure which is not actually fact. So anyway, that's it. So then what it did, it aimed at concentrating the power in the executive. There are three heads, right? Executive, third one, magistrate. So now this power is thought to be concentrated in executive. Okay. By what? By curbing the judicial powers. Therefore, what happens? Nobody can dissent it. You are unhappy. Shut up your mouth and keep quiet. That is the purpose of that whole lot. These amendments, the net result of these amendments. So, the 38th amendment says emergencies cannot be it is not subject to justiciability. It has removed the power of the courts as a check on the executive action during crisis. 38th, 9th amendment, what it says? It specifically bars the courts from hearing the election disputes involving the Prime Minister because she was thrown out by Allahabad court. So it is in a way saying that it is a response, it is a reflection, it is an arrogant reflection, if we can permit it to say, of to the Allahabad High Court verdict. Then comes the wonderful 42nd amendment. It is in a way called a mini constitution. Okay. So what happens? The directive principles are sought to be put above the fundamental rights. So many, which you are already aware. It curtails the jurisdiction of the Supreme Court. It strengthens the central government vis-a-vis the states. So the federal structure is a damage. Judiciary is addressed and curtailing their powers. And that which is guaranteed to a common man, we gave to ourselves certain fundamental rights, and we want to take them away by an amendment without reference to the basic structure. So therefore, what happens? These are all the things. Therefore, these amendments have to be stuck. They have attacked at the heart of the constitutional democracy. It is touching on the heart of the constitutional democracy. And what else it did? It has weakened the independence of judiciary, which is one of the basic tenets. It has weakened the process, and the integrity of election process and fundamental rights are all infringed. Then, if this is not checked, supposing these are not checked properly, then what happens? See, for every action, there is equal and opposite reaction. Is not only for science, even for law students. If an act is promulgated, it has certain implications. The purpose. Some purposes would be visible on the face of it, and certain other purposes have to be inferred out of the experience. So what is the impact of this? If these amendments continue, then what happens is, it is a constitutional autocracy where the judicial independence would be hollowed out. The fundamental rights could not be invoked. They stand suspended. Emergency power could be used at any time without the intervention of parliament or judiciary. It has gone into the hands. And the electoral process can be manipulated the way the executive wants. And the executive means with the help of the affairs, the Prime Minister. So therefore, what happens? In sum, the very basic structure of constitution as envisaged by the framers, that is democracy, rule of law, federalism, judicial review, these are all can compromise. Can compromise, they are not useless. They have become useless. This is the status. At that stage, the emergency has really put to test the spine of our other institutions like judiciary. There are lapses, okay. And one judgment that has come up during emergency is ADM. What is that name? ADM Jabalpur. It's called ADM Jabalpur case. So, all the judges sat over, and in that ADM Jabalpur case, that is ADM Jabalpur versus Shivkan Shukla 1976 case, it is also well known as a habeas corpus case. Okay, if somebody says habeas corpus case, it is referring to ADM Jabalpur case. Right. Everybody accepted, excepting one justice by name H.R. Khanna. He alone stood as a beacon to judicial consciousness. Okay. He gave one voice, is giving this dissent note. But the case will prevail because majority prevails. But this dissent note has taken a very, very, very important position in the jurisprudence and in the constitutional law. That dissent is important. So it is not necessarily your majority. Sometimes if your voice is straight, if you are onto the point, and if you are able to speak out the fact called as, then even your voice will have its own status in the process. So therefore, that is what, who? I just said a name. H.R. Khanna, Justice H.R. Khanna. Now, in this Jabalpur case, there are so many things. So, what is the legal issue that was actually falling for consideration? Let us see it. Whether a person has any locus standi. Locus standi is the right to file something. Whether a person has a locus standi to file a writ petition under Article 226 for habeas corpus during emergency. And already they are all out. So, when Article 21, right to life and liberty, is suspended, then can he file a petition under that article, that provision of law? When something is not there in the statute book for temporarily or permanently, how can you invoke that provision? That is one question. Then look at here, who are heading the bench? Ray, Justice Ray, Beg, Chandrachud, and Bhagavati. These are all not small people. They are legal humanists, no doubt. But they surrendered to the executive power of Indira Gandhi. Okay. So, once the right to enforce our Article 21 is suspended, no person can move the court for protection of life or liberty. When? Not in the regular court. Even if it is mala fide, and even it is without authority of law, or in violation of statutory safeguards. So therefore, because the Article 21 is not in force, the benefits which you can claim in the under writ jurisdiction 226 cannot be invoked, and court has no powers to do that. This is the understanding of these great luminaries. Well, let us not talk about whether they are influenced by the Prime Minister or whatever, let it go. But this is ultimately their fighting. So let us go only by the legal proposition. So therefore what happens? This means an unlawful arrest, an illegal detention, killing in the custody is not judicially reviewable. Now, look at the, if we are supposed to call it in other way, we would have called it as an atrocity. But let us not use it because he is a justice. Okay. Justice Beg said, the detentions were with a great sense of care and concern for the welfare of the citizens, echoing the government's justification. So whatever the government said, he admits as it is and says it's okay. But one gentleman stood tall. He said, nothing doing. This is my dissent. And that dissent is a historic dissent. Okay. So Justice Khanna disagreed with the majority and delivered a powerful dissenting judgment. It's a very big dissent, which we cannot read at this juncture. But then what did he say? Right to life is not something given under Article 21. It is inherent power. Justice Khanna says right to life and personal liberty is not merely a constitutional right. It is a natural and inalienable right. It cannot be alienated by anybody, by any force. So therefore, this is one observation. And that has to be protected, and that person's liberty is without any legal authority. whether or not you have a constitution, whether or not you have a written document, whether it is in force or suspended, it is an inherent power on every individual, the right to life. Then, what is rule of law? Rule of law is basic, is one of the parts of the basic structure. Enacted much before emergency, right? So that cannot be touched. So that rule of law cannot be touched even in the times of emergency. Because if that is done, if rule of law is off the board, what happens? It becomes the state taking law into itself. Nobody else has power. So therefore, no authority, whether it is state or anybody, is above rule of law. So rule of law is the topmost criteria. Then the third important point is, he was talking about the duty of the court. What is the duty of the court? The courts cannot abandon their duty. And now, after the entire thing, he has written a couple of lines that will put it as the last paragraph of his dissent. This one has to compulsorily read and, if possible, memorize. Because your students, it's better to memorize this. I'll read it for you. As observed by the Chief Justice Hughes, judges are not there simply to decide cases, but to decide them as they think they should be decided. And while it may be regrettable that they cannot always agree, it is better that their independence should be maintained and recognized than that of unanimity should be secured through its sacrifice. So what should be not be sacrificed? Judicial independence cannot be sacrificed. Their thinking faculties cannot be sacrificed. So therefore, a dissent in a court is the last resort. So dissenting in a court is the last resort, but they have a duty prior to that. Is an appeal to the brooding spirit of law, to the intelligence of a future day, when a later decision may correct the error into which the dissenting judge believes the court to have been betrayed. So this is how he has used all the power at his command to dissent the judgment and throw it into pieces. But anyway, 4:1, they cannot help, it has prevailed. So therefore, now what happened? The judgment is in force. Now, then came Keshavananda Bharati's case. This is one more very, very important case for us as a students of Constitution. So, after the Keshavananda Bharati's case, now the emergency is in progress. And all are yes, madam case judges. So then this man, who is A.N. Ray, Justice A.N. Ray, he constituted a 13-member bench. 13-member bench, what for? To review Keshavananda Bharati judgment. Now, whenever such a bench is constituted, usually when a legal proposition arises, then it would be referred to by another bench, and that would be considered. If there is no such reference by any of the judges, any of the benches of the Supreme Court, and why did they then constitute? It is because the CJA wanted it to happen, and the CJA gave a direction. At his instance, it has happened. Then, look at it. We were talking about Justice H.R. Khanna, who is a judge. And now let us talk about another legal luminary, a great jurist India has seen, by name Nani. Say it. Nani Palkiwala. So this man objected to this. As an advocate, he objected, saying that these are the aberrations. And he said, visiting a radical judgment is nonsense. So he was against that revisiting. Then Palkiwala's claim, then he said, one of the judges over there, Justice Murtaza Fazal Ali, he asked Palkiwala, If the Keshwananda Bharati judgment was against Mr. Palkiwala, your case, what would you do? So Keshwananda Bharati case is there. Now somebody went to Palkiwala, appointed him as their counsel. Now Palkiwala has to argue the case. But that Keshwananda Bharati case is coming in his way to get a relief for his claim. What would Palkiwala do? This is the question asked. That means better shut up. Don't raise all these things. This is a nutshell you have to understand like this. Correct? Then what did he do? He said, Palkiwala's reply was like this. Had it been the case, there would be no Supreme Court by then, where he could have come. Ultimately, this is what is it. Had it been the case, saying that if it is coming against my interest, the Supreme Court would not be there. That's then ultimately that bench was dissolved, and therefore Keshwananda Bharati is holding the field even today. But now look at the situation. Now we have to look at a certain other situation. What happened? What is the aftermath of this emergency? Simple. Who is that man who gave a dissent judgment? HR Khanna. So the line in who is the next CJI? This probability is HR Khanna because he is the senior boss. So now he has took aside. He was superseded to the post of CJI in 1977. Only believed. It is evident on the face of the okay because of his dissent. Even though he is the senior boss. Now look at the grudge that an executive can take. And the animosity that it has taken because something went wrong against the executive. This cannot be permitted in constitution. So that has to be protected. The basic structure has to be protected. Be that as it may. He was kept aside and another person came onto the seat. Now, that ADM Jabalpur case was thoroughly condemned by everybody. Every jurist condemned it. Common society, civil society condemned it. Legal scholars condemned it as one of the worst judgments in Indian history. In 2017, K.S. Puttaswamy versus Union of India right to privacy case explicitly overruled ADM Jabalpur case. So that is no more in the statute. For today, we did not consider ADM Jabalpur. So what is nonsense was made back to sense. Okay. The judgments rendered by all the four judges constituting the majority in ADM Jabalpur are seriously flawed. They are baseless. Life and personal liberty are inalienable to the human existence. Who said it? HR Khanna. And that's exactly the word imported into the new case in K.S. Puttaswamy versus Union of India. But unfortunately, do you remember the Jabalpur case here? Okay. 70s? 76? Shall I call it 76? Shall I call it 76? You have no objection, right? Then 2017. How many years? More than 3 decades or 4 decades. So long it took to go out of the book. Anyway, ultimately it is no more. So this is the status of during emergency. Now let us shift our focus to post-emergency. So we have seen what is pre-emergency, what is during emergency, and what remains is post-emergency. After the emergency is over, in 1978, 44th Amendment to Constitution. Who passed this? Not Congress government. It is the Janata government. Janata government. Let us not talk about names. Congress government, Janata government. Then, what is the word used in the 352 article is internal disturbance that is replaced by armed rebellion to be the ground for emergency. It's a very crucial thing. Then, if Prime Minister thinks that let me clamp emergency, go to the President and say, sir, please proclaim an ordinance clamping the emergency. This cannot happen. So, this amendment made it mandatory. This amendment made mandatory that the President to act and declare. It requires a written advice of the cabinet, not one person. Then it also prohibited suspension of Article 20, 21, even during emergency. Restored the balance between fundamental rights and the directive principles. Then, not only that, once an emergency, if it is clamped for any reason, periodical review by the Parliament and Parliament approval has become a mandatory requirement. So this is how they have protected back and restored back the basic structure and the rights given to the general public. Accepting the word an inalienable right. Then in 1980, Minerva Mills case is done. This invalidated parts of 42nd Amendment. What it did, ultimately the purpose of it is reaffirming the limited amending power of the Constitution, and judicial review cannot be violated. So Puttaswamy case overruled ADM Jabalpur and declared the right to life and liberty is inalienable. Even during emergency. That's it. Now the question is, this is the post-emergency period situation. Now, why are we having a seminar today in this? Because your college management and your principal madam is interested to know that, yes, my student should know the basics. What has happened, what is the difficulty, and so on and so forth. Now, in 2013, one of the judges by name, Honorable Justice Ravindra Sachar, he was retired by then. He wrote an article. It is titled Emergency of 1975 and Role Played by the Judiciary. This is the title. Why did he write this article? In 2013, after 77? He gave the answer for himself. He says, we are habituated not to remember the immediate past. And therefore, repeating the same tragedy is quite likely. That's a danger. You forget all the difficulties of emergency. If somebody asks you what is emergency, if you say, I don't know, then I can clamp emergency again, because you don't know anything what has happened earlier. So therefore, it is in danger of repeating the same tragedy. This thought has disturbed him. So then what he did is, at random, he questioned youth around 35 years old in the country. Youth around 35 years old. Then, because youth around 35 years make up around half of the population of the country, right? So, majority of them, overwhelmingly said, we just do not know any particular significant event of emergency. So, the entire people, 35 years and not, forgot emergency. They don't know. Then he went to above 35. So he thought at least old people may know. They also are on par with 35 years group only. So that was the status which has put him into a state of concern. But if we will remember, without fail, 14th February, Valentine's Day. No, don't we? And we make a lot of preparations over that. Starting January. So these are not my words. These are the words of the justice who is writing this article. I'm only quoting. I'm a loudspeaker. The material is here. Okay. Then he said, no information in newspapers about that 3 days. 26th June has come, it went off. Nobody talks about the emergency. Forget about front page. It is not there in the last page. Forget about bold headings. Not even this final script. This has put him under thought, and that is how this article has come into it in 2013. They also are they are victims of emergency. They keep a low like why? For various reasons. We will not talk about the reasons. No, no TV, no newspaper. They have silently kept, and there is absolutely no indication that something such a grave thing challenging the constitution, challenging our rights has happened on a particular given day. Which is a very black period. So then why these newspapers? Why these TV people? Why these opposition parties were keeping low? He says probably it is a sense of fear because they have enjoyed that emergency beauties. It should not be repeated. Right? In the jail, got beaten, no case, everything, all and sundry. So it is a day when India lost its democracy. And who said it? It is not Ananta Krishna who is talking. The great US president at that point of time said, India, this is a day when India lost its democracy. And the US president sarcastically says, boasted that America was now the largest democracy. Because otherwise, we used to boast. But now that we lost our democracy, US president says, now we are the largest democracy because India lost its democracy. So, but that statement was negated by the under the active and inspiring leadership of J. Prakash Narayan. Then that is how the US president's claims and boasting came to end. Only after 18 months, that's a different story. Now, look at this situation. This is what he said in uh, in his article about the status and the unacceptable silence of every strata of the society who ought to have raised their voice and updated the next generation about what has happened and what should not happen. What has happened and what should not happen in future. Unless you know something, how do you act? So therefore, this day has an importance every year. And that is identified by this college. Clap for yourself. The question is, why emergency could have happened, even though the constitution gave us fundamental rights, democracy being a basic feature of the constitution, as held much before emergency in Keshavananda Bharati. It's not that there is no resistance. Thousands went to jail, including all the ex-ministers, lawyers, social workers, all party people, anybody who raises voice out of the place, including the brave journalists. Okay, because there was a total fear that is gripping the country. And all this because rule of law has completely been eliminated by the Supreme Court in its ADM Jabalpur case. Then it is overruled by the view of 9 High Court cases. It has also overruled 9 High Court cases. So those who held that emergency, the illegal detention is not possible, is held by 9 different High Courts. All those things were been thrown into dustbin because of this. So, accepting Justice Khanna's dissent, it stood time for some time. Then, this is as one of the important jurists of this country says, it will remain as a hallmark of shame. It remains as a hallmark of shame. And he says, in view of the presidential order dated 27th June 1975, no person has any locus standi to move any writ petition under Article 226 before a High Court for a habeas corpus or any other writ or order or direction to challenge the legality of an illegal detention, order of detention on the ground that the order is not under or in compliance with Act or is illegal or is vitiated by malafidis, factual or legal, or is based on extraneous consideration. This extraneous consideration takes into fold everything that includes in the world. So, what is it now? Then, the emergency was lifted. Look at it. We are talking about which case? ADM Jabalpur case. This is not their own thought process. Just remember this word. This is not falling out of their own thought process. Ultimately, a council would represent, and the judges would also search for certain, what is that called? Judges taking the reference to the earlier judgments, that is something called, you have studied. Thank you. Precedent. So, one of the precedents is Liversidge versus Anderson case. It's not an Indian case. Okay, it's a Britain case. When it happened in 1942. In 1942. During a wartime. So, and then the House of Lords ruled against certain things. There also one hero was there. His name is Lord Atkin. He gave a dissenting judgment to that. Look at it. Here also all one side, excepting one who is dissenting. Even in 1942 case, all judges on one side and one Lord Atkin was on the other side in the House of Lords. When the judgment is pronounced, the entire English courts subsequent to that felt so ashamed that with a conscious decision that was made to throw the decision into a dung heap. The panel of it is thrown into a dung heap. This is what the expression they have used. So when it happened, 1942, there was an acceptance of some nonsense. One dissenting voice, still that is holding the field. Later on, they have dumped it into the dung heap. But we have taken it as a gospel truth and put it in ADM Jabalpur. I was talking to one judgment earlier. What is that? Foreign judgment? No, not foreign judgment. A foreign jurist who was speaking at where? Banaras Hindu University. Much before that, on the basic structure. And that has come into the process. By whom? By Nambiar sir's presentation in the court. So there is a jurist. He presented a case which is valuable and Supreme Court accepted it. Here is a case in emergency. Again, a case is there before the court and a decision is taken which is awfully thrown into dustbin in 1942 and we are talking about 76. 44 years later. See the judiciary at points of, and what is that? So therefore, this Lord Atkin says, he remarked about the judges who show themselves, see, look at his powerful statements, show themselves more executive-minded than the executive. This man says, these judges are more feeling executive nature minded than the original executive. That means you are doing an act which is not your proper duty. Okay. And commented that such arguments which might have been addressed acceptable to the Court of King's Bench in the time of so and so. That is. Then Justice Stable, who is a judge of London High Court, he was so upset to say that the status of judiciary has been reduced to my squeaking under the chair in the Home Office. Is there any other statement which is so insulting? But he said it. When he said it, when he said it, it was accepted without any reply. Because that was thrown to the whole society. Which one? Oh, sure. London High Court was so upset. I'll read the entire statement so that they may remember the name. Justice Stable, a judge of the London High Court, was so upset to say that the status of judiciary had been reduced to mice squeaking under the chair in the Home Office. Okay. Then in 1963, that is much before Jabalpur, ADM Jabalpur case is considered before Supreme Court, referred dismissively to the very peculiar case of Liversedge and Anderson. So a case which is thrown after in 63, which was prevailing in the field for 1942, is considered as a precedent. Does this fit into a precedent? Even a law student entering the law college on the day one probably would know if she touches the textbook. But what happened to the minds of these judges? This shows what shows? The discrimination. The towing the line of the executive. For what? For a promotion. Simple. Okay. This criticism of Liversedge judgment, this was available in various law journals and Law Quarterly Review 1970, much before Jabalpur, clearly spelled out how embarrassing this decision in Liverpool became to the English judiciary. And that's why Lord Diplock in 1979 was constrained to rule. He is ruling. For my part, look at his expression. For my part, I think time has come to acknowledge openly the majority view in Liversedge and versus Anderson was expediently and at that time wrong, and the dissenting judgment is right. He said it in 1970. This man said it in 1970. So this is how one more luminary, Lord Scarman, he says the ghost of that decision need no longer haunt the law. So the law is at stake in this. If the judgment continues, he says is the ghost of the decision need no longer haunt the law. So law is now safe by throwing that overboard. Then some of the contributors, they have made so many, and that was taken in majority decision by the Jabalpur case. Had the Supreme Court taken the same view as 9 High Court cases, the emergency would not have come into play and it would have collapsed then and there itself. But it continued. It continued for quite long. So, many people have come, they did so many things, and then ultimately, which set up the Indira government in the mid-1976. Now, I'll also share with you in this background. One, we have seen a UK case where a similar situation in wartime that has taken place and how it was thrown out and what are the implications of it and how awfully bad comments were passed not by the common man but by the judiciary and the legal jurists over a period of time, which ultimately was thrown off the board. And here is a Jabalpur case which met the same fate and followed the same case. And there was one case earlier in Keshavananda Bharati where a jurist comes to the court and says this is a basic structure, taking clue from another jurist, foreign jurist, a German jurist. So there is taking of good and also taking of nonsense. What is the difference in these two situations is the person sitting at the helm of the affairs thinking himself to be judge, behaves like number one. Thinking to be one of the of the executive is like this. So these are all things which you have to keep in mind. Then, one of the foreign 27, the politics of the judiciary. Let's look at the title. The politics of the judiciary. He explains in his textbook, was proved right that the independence of judiciary has become a myth. According to Griffith, that is the person who authored the book, when judges are confronted with direct political situations, they act in broadly similar ways. And behind these actions lies a unified attitude of mind, a political position which is primarily concerned to protect and conserve certain values in institutions. When the judges, except H.R. Khanna, declared the fundamental rights could be suspended during national emergency, the political position of the court exposed itself. The political position of the court was exposed itself, which practically annihilated the constitution during those days. Again, the court, while setting aside Allahabad High Court verdict that disqualified Prime Minister Indira Gandhi's membership, validated the retrospective amendments to the election laws. So, he says, the amendment absolved her from consequences of corrupt practices and found against her by the... So, he was commenting on these things. So, let me not go into the further details of that. He says, constitutions across the world, not Indian constitution or UK constitution or whatever, constitutions across the world are only an effort to reduce, if not to end, the evils of state power. The purpose of constitution is the executive should not take everything into its own hands. So there should be a check. That is the purpose of constitution. So it is there to reduce, if not to end, the evils of state power. So the constitutional text on its own would not be able to carry out this function in the absence of a political climate, ensuring its proper working. Indian politics has often not only failed the people, but also the constitutional liberal thinker, Mr. So-and-so, in Anatomy of State, he says, all the numerous forms of government have taken over centuries of all concepts and institutions that have been tried. None has succeeded in keeping the state in check. So there is every failure at every stage, not only in India, everywhere. So now that we are coming to the close of the whole lot, how shall we conclude this? Now we have to start somewhere, right? And already the bell has rung, and probably the rats should be running within the stomach. Okay? Anyway, what is the conclusion there? What will you take home from this? The whole exercise which we try to do. I'll share a joke and then go to the take home. An advocate like me has argued a case. And there is another advocate like sir who is on my opposite side. And he was addressing the judge. Sir, my learned friend Mr. Ananta Krishna, in a vague ambition of making a sound argument, could make some sound, but no argument. So, I only made some sound, and there is no material in it. So, there is no argument in it. Is that the case which we discussed for past 1 hour? Or did you get something else? This is my question to you. Something is there. If not everything, something is there. So, therefore, what is that you are taking? We have to have the constitutional vigil. We have to have the... Yes. The history of the emergency years, it will offer wonderful and significant lessons to us to protect the country's democracy. Country's democracy. The most important one is what? Constitution survives only when its institutions, executive, legislative, and judiciary, remain vigilant and not with rhetoric. So the reminder of emergency is constitutional rights are not self-executing. They demand constant vigilance. You must be very careful. Why? To protect the institutional integrity and also for the public engagement. It's not a legal document. Remember this. Constitution is a document, no doubt, but that's not a legal document. What it is then? It is a living promise. Constitution says these are all things protected for you. It is a promise. And who promised it? We ourselves promised it. Then whose responsibility is to protect it? Ours. So are we doing it? Next question. We'll see to it later. So therefore, a promise that no authority is above law. The liberty cannot be suspended by your acts. The democracy is not a gift of some government, but it is my right. Democracy is not a gift of a government. It is my right. Okay. Group photo తీయండి sir. మీ అందరూ Okay. Right. So therefore, it is not the gift. It is our right. Then I'll tell now, go back to in a summary. If you have noticed that Supreme Court considered the thoughts of Professor Dietrich Cornert. What is that he said? Implied limitations of the amending power through his submissions from the mouth of MBR, and that is accepted. The very same Supreme Court got influenced in ADM Jabalpur case by the case of Liversidge versus Anderson, giving during wartime, and that was thrown out. And which is said loud that it has felt so ashamed. The whole English court felt so ashamed. And it is thrown into a dung heap. That's the very powerful usage. So this is, with this background, what is this talk about and how Justice Khanna's dissent judgment, his dissent note, is significant to you law students. Not only the law students, and also to a constitutional thought. Constitutional thought. The value of dissent is sometimes greater than that of its conformity. When a proposition is filing before for consideration, the value of the dissent is sometimes very greater than the conformity. It is proved in 1942 by Lord Atkin and also Dr. H.R. Khanna. Then, the civil liberties need greater protection when not in the case of normal situations, during times of crisis. So, withdraw it. At the time of crisis, all the civil liberties is a simple nonsense. So, civil liberties need greater protection during the times of crisis. This is what he says. And independence of judiciary is not a procedural formality. It is the lifeline of constitutional democracy. So, these are the few things which we can take as a take home. But now the quick question is, and probably if I am permitted, madam, I would like to make a few questions for my friends. Apart from this, what H.R. Khanna, Justice H.R. Khanna said, I have a few questions for you. I would like recommend a seminar with you people, young prospective advocates, deliberating on these issues. I will post on issues now. First, invocation of emergency. How that power is unconstitutional and why such a furor has taken place. This is one question you need to investigate. Okay. First is invocation of emergency. How that power is, I'll send it across. Is unconstitutional. Why so much of furor? This is one question you need to investigate. When you start investigating, you get new revelations that will add to your value. Then, what is the power of constitutional framework and how is it misused at the time of emergency? Then, introducing your own rule or misinterpreting a scheme is the purpose of emergency that was introduced. So, what is that misused? What is that own rule? Or what is misinterpreting the scheme? These are the areas you may have to look from the constitutional framework. Then, how the rights of a common man was eclipsed during the emergency period. Then, what is the scheme of constitution vis-a-vis the democratic process of governance? The democratic process of governance vis-a-vis constitutional scheme. Then democratic governance and role of rule of law in that. Then these are the questions. May the freedom of thought and courage of Justice H.R. Khanna and the like guide you in your future endeavors. Thank you for this opportunity. Thank you.
Behalf of the institution, College of Law for Women Andhra, I feel happy. I feel happy that students are educated with reference to emergency, need, and pre, that means during emergency and post-emergency situations. How the judiciary has to react, the executive has to work, and how the legislature has to take steps. We have discussed with reference to amendments, different stages. The significance of amendments in the Constitution. What are the problems that were faced during and after emergency? God has highlighted you. So you have to learn any law with respect to socio-economic political risk. Without that, life is not there. So what happened in good old days means, don't think what Chandrambabu Naidu said, history is never related. History is always related. History will teach you what are the mistakes previously done. Why you have to take precautionary steps that mistake cannot be done. Okay. So we are studying law. We will learn 50 years back what are the problems faced by the common man. Because now we are saying anything, your mother says, no, no, we are not interested. Your freedom of speech and expression is not there for anyone during that time, including all common men also. You know the value of until 1918 and use it in reasonable way. Some reasonable restrictions are also imposed. But under the protection of the country or the constitution, if you have to use, it is good. Otherwise, what Indira Gandhi has learned from her power and what later she has proved without power, how the problems used to arise. So you are also going to face this issue. But so Sir has given elaborately the reasons of emergency and what to be done, what do not be done by the building advocates. Thanks for you on behalf of the department and also national members hearing your comments. And it's not to be the thing person now. Actually, our program. Thank you for all.